Hello and welcome. Today we've got Jason Fick, the founder of the Social Media Freedom Foundation. And today we are going to be discussing Section 230 and censorship on social media and the court system and much more. Now, just before we begin, you can subscribe to our Telegram channels and to nicholasveniamin.com for my free email updates. And if you're watching this for the first time on YouTube, I will leave the link below in the description for the full interview. Unless, of course, myself and Jason can choose our words wisely due to the insane censorship that's happening right now. Jason, thank you for joining me. How are you and what have you been up to?
I'm well, Nick. Thank you. Well, we've been up to fighting for freedom online. As you said, that we are the Social Media Freedom Foundation, and we are working diligently on upcoming lawsuits against the United States to restore some of those freedoms against censorship and the antitrust issues.
So let's just have a little bit of a background about, yourself, your experience in the censorship, and then what you did about that with the court system, and then we can take it further after that about the big thing that you're going through right now.
Yes. So thank you, Nick. So I had started a magazine years and years ago, and I had turned to social media because they had offered a free platform for all ideas, and that we could build our reach and distribution. Little did we know that after, they've captured us all, that they would actually extort the reach and distribution for money. But I built an audience of in excess of 25 million on paper, but I believe it was closer to 38 million at my peak. It was huge. Now, I never tried to be personally famous. It was just me behind the scenes running very large pages. And I built a marketing company out of it, and it was very successful. And then what ends up happening is that, Facebook's business model was essentially to sell reach. Well, they, of course, had to reduce the reach of anybody organic. It's directly in competition with their users. Well, they did that to me, and they wiped out most of my business. In fact, actually, one night alone, they took out 6 pages with over 14 million fans. That's devastating. And the reasoning, they didn't give me one at all. I hadn't done anything really wrong. And in fact, we actually caught them, because about 4 months later, I had gone to another competitor who spent a lot more money than I did with Facebook advertising. And they asked their reps if Facebook would restore my content, like restore my pages. And they said no, unless that company owned it. So I sold them the pages unpublished. And sure enough, right after the contracts were signed, all of the pages supposedly now no longer violated the community standards. Magic, same content. So all that proved is it never has anything to do with content. It was simply that they didn't want me making any money on there. And that's my approach to this. So what do? Personally, I sued Facebook in 2018, and we alleged anti-competitive behavior. Now, Facebook even went so far as to completely lie about me. They made some salacious comments in the court findings, which, of course, the media immediately jumped on, which are completely untrue, 100%. But regardless of the defamatory claims, we had an anti-competitive, complaint. It was pure and simple. You can't be, because what most people don't know is that the beginning of Section 230 says that it has to be done as a good Samaritan, right? In the interest of the public for the good of others. That principle cannot stand in the face of anti-competitive restrictions, period. You're just not doing it for the good of others. My case went all the way to the Supreme Court. They denied it. They just denied me and dismissed me. And then the Supreme Court didn't hear it, unfortunately. So here we are. We knew we were right. And crazy enough, there was another case called the Enigma versus Malwarebytes decision. And they came to the conclusion that the Good Samaritan provision doesn't cover anti-competitive behavior. Sure enough, we were right. So we went back to the Northern District Court, and we appealed. We did what's called a Motion 60B, and we said your judgment's wrong. These two cases conflict. They're exact opposite of one another. And the court, once again, turns out actually the judge, and this is the first time I've announced this, the judge is retired. So he's essentially just did nothing more than rubber stamp this thing and send it through and say, nope, you're still dismissed. Well, they didn't even look at it. The reality is that the whole statute has to work congruently. They call it harmonious, right? That's the way our laws are built. They can't be redundant, repetitive. They have to work as a whole. Well, they're not. It's not working that way. And there are proponents of these people out there that want to protect 230 because they have power. They can restrict us unfettered. They can go out and they have immunity from doing this. Well, here we are. We're going back to the Ninth Circuit Court in just a few days, actually. As a matter of fact, Nick, this is a pretty big announcement. We're going to be filing another appeal to the Ninth Circuit Court again. And we've got this argument really narrowed down. And this is in regards to anti-competitive behavior, more of the antitrust side of things. But this caused a whole other avenue that we now can talk about. This is what we believe may be the final solution to this whole problem. And that is that the Social Media Freedom Foundation, we formed this, and anybody that wants to support us, it's socialmediafreedom.org. Again, that's socialmediafreedom.org. And on there, there's an executive summary that explains in short terms, short 15-page terms, what we're about to do, which is bring what's called a Rule 5.1 constitutional challenge of the law. There is no money involved. I have no personal gain in this. We have worked for close to 2 years and come up with a comprehensive lawsuit against the United States of America. And we are challenging the constitutionality of the law under multiple doctrines and multiple canons of statutory construction. We're going after them. And a lot of people, you may even be thinking this, Nick, well, what if I lose? Mm-hmm. There is no losing this, because in a constitutional challenge, what they're required to do is they either have to give us declaratory judgment, meaning they have to explain how Section 230 is congruent with our Constitution. It has to be constitutional. So they will either fix it in that circumstance, get it to work, or they strike it. And if they strike it, portions of or the whole Section 230 could come down. And we're not just pitching things in the air here. This is not, pie in the sky, just, throwing a Hail Mary. I can tell you, and I can't tell you who, but I can tell you we have congressional support on this, sitting congressional support on this, to basically say, yeah, this thing's broken and they're not getting it fixed. And the judiciary has to look at this and go, this is wrong, because otherwise we're going to lose not only this nation, because of course we're founded on the principles of freedom, but we stabilize the rest of the world. This country. If we lose freedom here,
we lose
what's
everything.
Next? We just watched what happened in Canada. That was unbelievable, Mm-hmm. So that's where we stand. We have these upcoming fights, and we're fighting on behalf of all of America, especially the Social Media Freedom Foundation. So, again, this has been out of pocket this whole time.
Are you allowed to, tell us at this stage what type of things that you are going to be bringing them forward, how you're going to present your information, and what you think constitutes to solid grounds?
Well, okay. So, for example, a lot of people don't know what 230 is. They know it's a law, right? They know it's some sort of statute, but what type of law? So a lot of the people that are supporting this, that really, they say that they're experts, but they're really not, because all they've done is they've read the existing precedent, right? And for those that don't understand, the cases that exist around Section 230, those cases in many cases are wrong. Matter of fact, one of the first ones that ever existed, Zoran versus America Online, got it wrong. I'm not going to go into the technicals of it because it's going to be over most people's heads, but essentially the reason that it's wrong is because the type of law that this is what's called an administrative law. And it says to whoever these private entities are, right? It doesn't matter if they're public or private entities, they grant an authority, right? And it's right there in the text of the law. It says protection for Good Samaritan blocking and screening of offensive materials. So if we look at those words, protection, what is that? That's the consideration. That's what they get, right? And what do they have to do? They have to block and screen offensive materials. So that's Congress's directive. That's what Congress said to do. And if they do it, they get the consideration. They get the protection, correct? Mm-hmm. So they'd have to follow a state directive in order to get the protection. And the Good Samaritan, that's in quotes, and this is funny because most of the experts that I run into that think they're experts, I can stump them instantly. Why are there quotes on Good Samaritan? Nobody seems to know. Most attorneys, they have no idea. Why are there quotes? Well, there's a reason. It's something called the general directive or the general principle, also known as an intelligible principle. And what that means is that when Congress, like for example, our Congress is not going to decide what size fish or trout that you can take out of a stream, are they? They're not going to make a law that says it has to be a 12-inch long trout. Why? Because it's an inconsequential decision, correct? Mm-hmm. It's something that they're not really hyper, focused on. So what do? They form the Fish and Game Commission to do something called filling up the details. And what that is it's a transfer of delegated power to a commission, and the commission sets these smaller rules. Why? Because Congress doesn't have the time to deal with what size fish you catch, right? Well, that's the same thing that 230 does. It says, hey, we need you to block and screen offensive materials to protect children from harm. We'll give you protection in return if you do it in a Good Samaritan general directive, meaning that's how they're saying to do it. That's the how. So okay. Does that help you a little bit in terms of like how it's structured?
I'm understanding that what they do is they have these laws in place and they can be very ambiguous and open to interpretation to basically break the law when it suits them. Right. That's what they're doing. They're abusing the law. They have it written in a way where they can abuse their law and use it the way they see fit, depending on different circumstances that benefits them and supports their agenda, and censoring anybody that's a threat to them, like what we're doing. We are exposing the truth. We are exposing their agenda. I get censored, you got censored, everybody does, and it's a disgrace and it shouldn't happen. Is that right? Did I understand you correctly?
Yeah, so that is exactly it. It is that the rules are so vague, right? That's a good word to use, right? Vague, arbitrary. The rules are not standard. They are enforced however they choose, right? Well, the thing about that is that when the government delegates regulatory authority, which is what the type of law is, the fact that it has an intelligible principle says that it is an authority. It flat out is, right? That goes to the private entity, and the private entity is then told that they can restrict access to or availability of materials that they consider, and the lowest standard being otherwise objectionable.
But who's they? They should specify who's they.
Well, the provider or user, whoever is choose. So the interact, and that's another thing that's confusing is that there's an argument of publisher or distributor. Well, I can tell you right now, publisher and distributor distinctions do not exist within Section 230. It doesn't happen. They've actually blended the two together because the jobs of the two is that they've essentially given a distributor a publishing job is really what has happened. Mm-hmm. And the problem there is that we have this idea of, are they a private actor acting on their own behalf, doing whatever they consider to be objectionable, right? And they say, well, they have a First Amendment right. Well, I can squash that in the actual language of the law. They are a state actor, and here's why. And follow with me, because it's a little complicated. I think your audience will like this, because this argument has not been made by anybody else, but it is right there in the law. So, language matters. The order of operations matters in math, right? Well, order of operation in English also matters. Under 230C2A specifically, it says any action voluntarily taken. It does not say any voluntary action taken, right? Mm-hmm. So if it says any action voluntarily taken, well, if you look at voluntarily taken together, the choice is whether to do it or not, right? But the action, it doesn't describe the action. It doesn't say it's a voluntary action. It just says voluntarily taken. So whatever the action is, any action that they do choose to take has to follow the rest of the statute, which says to restrict access to or availability of materials that are otherwise considered, and we'll just skip ahead to otherwise objectionable, whether or not such materials are considered constitutionally protected. Who wrote that part? That came from Congress, right? That's an obligation by Congress. It says you have to do this. And if you take any action to do this voluntarily, we will protect you. Meaning they can voluntarily choose to engage in state action. Because if you work it backwards and they go to court and they say, well, we want protection, we want civil liability protection. The court then asks, did you follow the congressional delegatory obligation? They have to do that, right?
Mm-hmm.
Because if they don't do that, then it was private activity, then they're held liable. So if they did whatever it was, it has to fall within the directive of Congress, which means they're a state actor. They voluntarily chose to do it, but it's still state action. It's a very different argument of most people arguing, well, the government didn't tell them to do it. Well, they did right in the law itself. It's right there in the statute. So that's another perspective.
Well, that's very interesting. It's a very legal perspective that I think that everybody needs to understand. If you win this, and I'm sure you will, we should be saying when you win this.
I hope.
Are you saying that you could be holding the key right now to removing I'll have to be careful with my words here because I don't want to be censored, but removing the power of what's going on with the censorship from YouTube? So that means it would enforce YouTube, Facebook, and other people that are subject to 230 that they need to clean up their act. What do you think?
Well, putting in the true perspective, YouTube and Google would still have a First Amendment right to do anything it chose to do. They could still take your content down. They could still put it up. That's why this isn't a protection for First Amendment. Their First Amendment is ensured by the Constitution. They can still do it. However, what it does remove is the liability protection, which is to say that if they take down your offensive content, you're not going to be able to sue. You're never going to get through the courts because they're going to go, no, what you said was terrible, right?
Mm-hmm.
But if, for example, like in my case, if they took down my business for anti-competitive, unlawful reasons, or let's say, for example, they discriminate based upon a protected class like race or gender or handicap, etc. If they do things that are unlawful that break other laws, they will no longer be protected by the government because they're now breaking the law. They don't have absolute immunity. Yes, they will still be able to censor. Yes, they will still be able to put stuff up. Yes, they could put content up, but they will be responsible. One thing I know that it will affect for sure, fact checking. Fact checking is nothing more than laundering content production through a third party. That's all it is, because the site identifies it. So they choose it. They send it to the third party fact checker who they pay. So they employ them. That fact checker then has to rate it false. And I'm saying these things no, these are actually from a quote from Tessa Lyons from in Facebook, how it works. They send it to the third party fact checkers who rate it false. They mark it false. And then they create more context, meaning they create information. Well, so Facebook pays a third party to create information. How are they not editors? They're the publisher themselves. They're the ones creating. And the reason I say this is because if you read the law, there's a section for definitions, right? It explains what things are. An information content provider is anyone responsible, even in part, for the creation or development of information. They're responsible. They're a content provider.
So you're saying that they would create an article to back up their claims to debunk something that they don't want to get out.
And if the site is paying them to do it, it's laundering third-party creation of information in order to say, well, we didn't create the information. Yes, you did in part. You are responsible in part for the creation of that information because you paid them to do it. They would not have been doing it there if they weren't being paid by you. End of story.
Don't you think it should be illegal for Facebook and YouTube or Google or anyone to pay fact checkers or a third party to create these articles?
No, not at all. No. If we have to keep a clear mind on this and think of this rationally, no, absolutely. I think that they have a First Amendment right to say or do whatever the heck they want. The government does not have the right to immunize that behavior. If they say something defamatory about me and they paid for it, I should be able to go into court and sue the snot out of them.
Mm-hmm.
That's the problem. It's not that they can't do it. It's not that they shouldn't do it. They can do it all they want, but they should be responsible for what their actions are.
And if they're able to do whatever they want and say whatever they want and pay somebody to create any article they want, then we should be able to say what we want to say. So it's not double
Correct.
standards. That's the point here, right?
Correct. That is why this is the Social Media Freedom Foundation, not the Social Media Conservative or Liberal Foundation. Mm-hmm. We are bipartisan because we have one goal in mind, and that is to restore everyone's freedom. We don't believe that it should be taken from the providers, the service providers. I believe that they should have a First Amendment right too. I believe even if you don't have a First Amendment right because you're not from this country, from the United States, I believe that it is an inherent God-given right that everyone should be able to speak their mind, even if it's hateful, even if it's offensive or objectionable, unless it's a direct threat, which is, there are impermissible things that are said. And it's because they're widely understood to be terrible things, and there should be some standard of decorum. But realistically, everybody should have that right to be online, to be able to run their business and not be, molested by these companies.
Do you think YouTube will ever be cleaned out? Meaning, I know they can, remove content, but they won't be liable, which means that the content creator can then sue YouTube and YouTube won't be protected. Is that what you're saying?
Well, yes. So essentially, they could remove your content. And if they remove your content because they feel it is offensive, it doesn't necessarily mean that you'll win a lawsuit. Everybody thinks that, well, they took down my information and that I was harmed because my speech was silenced. Well, if the government steps away, meaning if 230 disappears, the private entity does have a First Amendment right. They can say whatever they want. They are responsible for what is said. So therefore, if they take it down, the question is, were they harmed? Where was the harm? If they shut down your speech, is an actual liability harm? It depends on the circumstances. But again, and most people don't realize this, that what immunity is, what Section 230 does is it's a protection from suit, meaning you never get to court. The courts decide it before you even get to the merits, meaning what happened to you? Why was it taken down? Well, that's something that should go into the court, and then they look at it and go, okay, why did they take it down? If they took it down because, let's first say that you're Black, that's unlawful. It's discriminatory. They should be civilly liable. If they took it down, but you just happen to be Black, but there's no actual correlation to the discrimination, then you are not liable. It's all based on the merit. So those cases have to at least be heard. A judge has to look at them and go, was it done wrong? Were they liable? What did they do? We don't get that far with 230. We don't even get it. I have literally never once spoken to a judge in 3.5 years of litigation. It's bizarre.
So once we win this, social media, freedom, do you believe that the censoring will stop? Although I know you said that, they can censor whenever they want, but they won't be protected. So we can take them to court, but you're saying we might not always win. But do you think that eventually, personally, do you believe that it will all be cleaned out? Do you think we'll have freedom? Like Truth Social, they say we will have freedom on there. Do you think we will have freedom on these platforms?
If you remove the liability protection, lawful speech will not be taken down. So the censorship will drastically reduce. When they do take content down, I think that they're going to be much more strict about it, though, because so another thing that really relates to what you're asking is a lot of people misconceive how distribution works. If you think of it like a bulletin board, right? These sites and Reddit and those kind of sites are really a bulletin board. The provider of the site, meaning the person who the company that creates the site, is not responsible for what somebody else does. It's a fundamental, pretty much easy thing to understand, right? Because they're not what they call materially contributing to, which means a divisible action. Like they didn't do anything. Yes, they provided the site. Yes, they provided the service that put it up there, but relatively they're inactive. They're passive. The confusion people think that has arisen from 230 is that they believe that they have the right to knowingly choose or allow content. That's the job of an editor. Now, the difference is if you're standing at the bulletin board and you own the bulletin board, people are putting their notes up on the bulletin board is very different than handing the notes to the owner of the bulletin board. And then that owner choosing what's going up because he's acting as a filter. He's materially contributing to that information. So what happens here is what you're talking about is what changes. If they knowingly allow content, they will actually be responsible for it because they're materially invested in it. For example, there was a case, Doe versus Twitter, where this Jane Doe had a video, and it was an illicit video of her underage. So, I mean, it was unlawful too. It was child pornography. And the video came back up on Twitter or maybe it was Instagram. I may have confused the cases, but the point is that she asked for it to come down and Twitter chose to allow it. Chose. That's very different again than it just remaining. They chose to continue hosting it. So now they're now partially involved in it, right? Well, they still weren't held accountable. And the point there is that no, they made a conscious decision to provide content. They looked at it and they knowingly did it. There's a difference between unknowing and knowing. Well, it got all the way to the State Department, the Homeland Security. Homeland actually had to get in touch with them and said, take it down. And that was when they finally took it down. But it got 247,000 views since that point. That would not have happened had they made the right choice. That choice is something they should be responsible for, period.
Do you know what the consequences for that was?
I believe in that circumstance, they were actually, there was one portion of the case that held and the rest were dismissed under Section 230. And that's the problem is that that's not the type of activity and behavior that should be covered. And it shouldn't, given the correct understanding of the existing law, much less the mess that they've got going on.
So you're saying now that you've got congressional support going forward with your operation.
Yes.
When does this begin?
I actually have a call in about half an hour with the congressman's office, and essentially they've read through we have an executive summary. And for those of you that are out there that are listening, socialmediafreedom.org. If you go down on the main page, it's called Restoring Freedom Online, and there is an executive summary down there. Now, we are going to be updating it because we have a newer version of it, but it gives you an idea of what we're doing. The congressman and congressman's counsel both reviewed it. Several other council members reviewed it. This is the most comprehensive case that has ever come forward. We have hit it from every direction possible. There's like so many different things. There's even a typographical error in this thing that we believe may in itself damage this thing. That's coming out. I don't want to totally announce that one yet, but there is actually a mistake in the law, and mistakes can't happen. They're not allowed to happen in statutes. They have to be correct. Anyhow, the long and the short of it is the congressman agrees with our premises, supports our premises, is going to be submitting to many other congressmen for support. And we may have amicus curiae coming from Congress to go to the judiciary to look at Congress's own law. That's relatively unheard of. And that's because we have spent so much time working on this. And again, I've done all of this out of pocket. Everybody thinks that I have not done this for fame, for fortune, for anything. If anything, I'm losing money on a daily basis. Facebook even went so far as to kill my other contract, which wiped my own income out. That's how hard I've been fighting for this nation.
Absolutely.
You've got to do the right thing or we're going to lose it.
Absolutely. And also you're putting yourself at risk as well.
Mm-hmm. Absolutely. Well,
have you
let's put it this, let me make this publicly announced. I am very happy. I have a great family. I am not in any way suicidal. And if the cameras are turned off in my cell, just so you know.
Don't worry, we're making that very clear. But Jason, it's been a great honor to have you. Thank you so much for sharing that. I wish you have my viewers and my support. Anytime that I could help, please let me know. My platform is your platform to share, everything that you're doing to the viewers. You're doing a great job and it's fantastic. Is there anything else that you'd like to share to the viewers before we finish with this interview?
Well, I'd love to come back when we finally file the constitutional challenge, which will be in a probably about 3 weeks. when we go public there, and just make sure people know we definitely need the help. Go to socialmediafreedom.org. We're working for the entire world right now, trying to solve this whole problem. But thank you, Nick. Thank you for having me on.
Absolutely. Thank you. Thank you so much. And we'll speak very soon. Bye-bye.